Let's get started. Hope everyone's doing well. We are now on class 24. If you can believe it, we are almost done. We are basically through the semester, believe it or not. So a couple quick announcements. First off, Wednesday, there's no class. So if you come here, I won't be here, but you're welcome to come and do whatever you want. Monday, a week from today, we're having a guest lecture. We're having Justice Brett Busby. He's a judge on the Texas Court of Appeals for the 14th District. He will be here Monday. He actually was involved in the litigation of one of the cases I signed, Severance versus Patterson. He was a lawyer in practice before he became a judge, and he knows a lot about this topic. This is the Texas Supreme Court case involving beach erosion on Galveston after the last big hurricane. So please come on Monday. Be sure to do your readings. Make South Texas proud. In years past, occasionally classes have slacked off those readings. It's embarrassing. I want them to come back and enjoy it. So please make sure you do your homework and you're familiar with the case. Okay. Any questions? Anything on your mind? Nothing in your mind? So our topic for today continues the discussion of takings. So let's do a little bit of review from our class last week to make sure you're all on the same page. One of the more complicated aspects of this final unit takings is that there are a lot of different tests that the Supreme Court has developed in different circumstances. And keeping track of which test applies to which circumstance is really the most difficult part. And I can say without any exception that half of you on the exam will apply the wrong takings test for a given fact pattern. Without exception, it happens every year. No matter how clear I make it, half of you get it wrong. So let's try and make it maybe a quarter this year. So let's walk through each of the different kinds of takings, okay? So the first one we did was from Loretto. Okay, where did I finish last time? Okay, thank you. So Michelle, what was describe the sort of taking at issue in Loretto? Good. Okay. I meant in your own words, but what was actually happening? Very good. So Loretto is what's called a permanent physical occupation. This is what's known as a categorical regulatory taking. Natasha, do you remember why it's called categorical? It's automatic. There's no balancing. Okay. When you have this sort of permanent physical occupation, and again, the easiest way to describe this is if you're literally hammering a nail into something, or you're literally taking somebody's box full of raisins, right? You say this is a permanent physical occupation. This is known as a categorical regulatory taking, and there's no balancing, right? You don't consider the impact on one party or the other. You don't consider how significant the taking is. The mere fact that this act has been done violates the Fifth Amendment, and compensation must be provided. This cannot be explained as an exercise of the police power. This, in and of itself, is a taking. It's not under the police power. Everyone get that? Okay. So then, Peter, discuss Hadachek. What was going on in Hadachek? All right. You don't remember? Stephen?
There's owner of a clay and brick company. And there's argument that it was a public nuisance per se in the manufacturing of the clay.
Okay. Now, did they bring suit? Did any neighbors bring suit for a nuisance? Was that the nature of this case?
I don't think so.
What was the nature of this case?
It was just an argument that it was related to public health.
Under what circumstances did this case arise? What happened? There wasn't a nuisance suit. What happened in this case that gave rise to the case?
I mean, there was an ordinance.
Ah, a law. Okay. The city passed a law effectively saying within city limits, you could not do what?
Manufacturing.
You cannot bake bricks. Okay, everyone understand this, right? Now, Ben, did this physically take Hadachek's property?
No.
Did it tell him that he couldn't live on it or work on it or anything else?
No.
What did the ordinance actually do?
It said that he could technically harvest the clay, but that he could not make it because it was noxious.
Okay. So the act in this case said you could not, extract the clay from the ground. Was this, Ben, an exercise of the police power, or was this a taking? Okay. Why was this an exercise of the police power?
I guess because in that case, it would affect the community. Well, it was pre-zoning. It was a pre-zoning decision.
Good.
It was on the same basis of sort of best interest of public health to prevent
Okay.
that sort of usage.
Okay. So effectively, what was at issue here was it was an exercise of the police power to control a nuisance. Okay. Now, even though there were no allegations that there was any a smell or odor or noise or traditional nuisances from this clay field, the court said it's close enough, right? If the state determines that a specific usage may create a nuisance, they don't have to wait for someone to bring a tort. They don't have to wait for someone to sue individually. They can eliminate it as an exercise of the police power. Okay? And because it's an exercise of the police power, you do not need to pay any just compensation. Everyone with me so far? This list is going to keep, I'll get you a second, Norma. This list is going to keep getting longer and longer. We'll have it probably almost like, I can't remember, like 8 or 9 by the end of the semester. So this list will keep getting longer. Make sure you keep this list ongoing in your notes, okay? Yes, Norma?
Why is it that because this ordinance was passed after we've already there established doing clay, pulling this out of the ground?
Ah. So what's this topic? We discussed this before. Let's see if you remember, where someone was not grandfathered in, where the land use was changed and had to make the change immediately. Remember that case? Amortization. Close, apportionment, okay? So yeah, the question is, how come they weren't grandfathered in? So here is the difference, right? In the amortization case, it was an adult bookstore. And they said, you need to shut down the adult bookstore immediately. What was it, 60 days, 90 days, whatever it was. In that case, there was no indication that the adult bookstore was a nuisance. There was no indication that the adult bookstore harmed anyone other than maybe offending morals. Here, it was a nuisance on day one and to stop on day one. So generally speaking, you're not grandfathered when you're causing a nuisance. Grandfathering only applies when it's a non-nuisance application. In fact, that's how they get around it. By labeling it a nuisance, they say it has to stop immediately. Does that make sense?
This one specifically didn't smell.
Ah. So Norma, let me ask you this question. When the government passes zoning laws, do they have to be precise and make every zoning law fit every situation perfectly? No. What happens? Well, how do courts generally view zoning laws? In terms of constitutional laws, we call rational basis review. Effectively, so long as the government has some plausible reason why this law is necessary, even if in a given case it doesn't fit, even if this brickyard was clean, the government can use broad strokes and have a general law to apply to everyone equally. And the courts do not second guess that.
So then, even if there was this rational basis, couldn't we say that there was wasn't an undue hardship because financially, even though he was still allowed to like pull this stuff out of the ground, would you say it was a lot more expensive to move to a different area?
If it's an exercise of the police power, does any of that matter? No. If it's in the takings clause, right, and we'll do this with Penn Central in a few minutes, right? But if it's under the takings clause, then you actually consider the various hardships. But if it's considered an exercise of the police power, that doesn't matter. Now, the question underlying Norma's back and forth is, when is it a taking and when is it a police power, right? Why wouldn't this be a taking? Because it's caused such a hardship to have a check. And the short answer is the court hasn't sculpted a good line between when it's a taking and when it's not. And Penn Central, the case we'll do later today, perhaps creating the most confusion. Which if you were confused when you read Penn Central, congratulations, you read it well. Because it's not a very well-written opinion. It's been tormenting property students now for 40 years. But the court has not drawn a good line when it's a taking and when it's a police power. Unfortunately, that doesn't help you very much because you have questions you have to answer, but we'll do our best to walk you through it. Other questions? You're not right spot? Yeah, go for it.
Is there a way to challenge the police power usage that it's hitting, like it's not hitting everyone the same, or it's hitting differently, or that they're only enforcing it against
Selectively?
Yes.
So do you remember the thing about spot zoning? Remember we had the case from Rochester, Minnesota, where they wanted to build the condos near the big hospital, and they basically made a one-time exception to the land use law? Okay. In certain cases of spot zoning where a law is changed just to benefit or perhaps harm one person, courts may be skeptical. But in this case, where they pass a law applying to everyone equally, right, that's not going anywhere.
But like in the Loretta case,
Mhm.
that there were other bricklayers in the town that were not being permitted.
Had to check.
I'm sorry. Yeah. Yes. Okay, so it's basically they have to hit it all differently, and if they don't.
Basically, under the rational basis review, they review the courts apply. The law does not have to fit every situation neatly. If the city passes a general ordinance saying no one can bake bricks, even if some are dirty and some yards are clean, the government can use that kind of broad approach, and the courts will not second guess it. What would actually be problematic, imagine the situation where there's only one brick baker in the entire city, and the city said, we are prohibiting brick baking. That could give rise to trying to target this one company. But because there were several in the region, the suspicion they were trying to single this guy out, courts will not jump on that.
Okay, I thought I had read that case where they had only zoned that one bricklayer out, and the other ones were still allowed to do it.
Even if that were the case, right? Even if it were the case that they only affected one business, courts probably still wouldn't get involved. It would have to be something very obvious where they basically said this bricklayer by name, right? They target this business. But it often happens that zoning laws are made in such a way that the burden's felt on very few. For example, in Penn Central, right? Out of all of Manhattan, a big city, only 400 properties were designated for this historical site. And the court said, well, we're not singling this out because for 400 properties they're given this. Well, there are probably tens of thousands, maybe hundreds of thousands of property owners in Manhattan. I don't know the number, right? And only 400, and that's a pretty concentrated burden. That makes sense? Are other questions before we get started? Yes, sir.
Is there any sort of standard for like review on? I mean, so when there's a zoning order or anything like that, we said the courts generally don't get involved. They don't like overturn it. Is there like a clearly erroneous standard or anything that they do look at it for?
It would have to effectively violate due process.
I mean, what about something like if they decided that apple orchards were per se nuisances, and very obviously apple orchards are not?
Well, don't they drop trees that rot? Don't they drop apples
Okay,
that
so
rot? No, I'm not being facetious. I'm not trying to fight your hypothetical, but courts do not want to second guess what a city determines is a nuisance. I mean, consider the Ashby case, which I mentioned a few weeks ago. What the jury found was a nuisance in this case was because it was out of place and didn't fit in with the surrounding environment. Does that harm anyone other than, people don't like it? Property law, for the most part, is not done through the courts. There's very little judicial review. This is what makes Loretto such an outlier. Because it was an actual physical appropriation, only then the courts intervene. Like with Penn Central, we'll do in a couple minutes, there the court basically says, I'm going to make it so hard to find a taking that this law doesn't even matter. And that's pretty much the law today. Anything else? Keep these two tests in mind when Justice Busby is teaching you guys on Monday, we'll come back to how to check because we have a couple cases that are based on it. So make sure you at least remember the frame for how to check. Okay, let's go on to the first case, Penn Coal v. Mahon. It's a fluke of history that both of your cases that involve Pennsylvania in it, which will confuse you. Make sure you distinguish them. There's Penn Coal and Penn Central. Don't invert them. Someone does that every year, and I give them a warning, and they don't listen. So don't do that. All right, so the first case involves a topic near and dear to our hearts here in Texas, which involves mining, mineral rights. Now, you will take at some point in your legal career a class on oil and gas and mineral rights, and I will not pretend to give you even the anything more than the very basics. But the general doctrine is when you sell someone a piece of soil, a piece of land, the presumption is that the person owns everything underneath and indeed everything to the sky. It's this doctrine called ad coelum, right? Where you own everything below and everything above. Now, you don't have to do that. What if you just want to keep your house in the surface and you want to sell to a mining company your subsurface rights? That's fine, right? You can do that. You can separate the surface rights from the subsurface rights. There's no problem there. But a problem does arise, as you might imagine, when someone is digging underneath your house. What is that problem? Well, if you've ever been to a sandbox and you start removing sand from underneath the bucket, eventually the bucket falls in. So this problem is what's called subsidence, right? S-U-B-S-I-D-E-N-C-E, subsidence. And these pictures illustrate effectively what happens, right? If you look at your screen, you can see it better. But effectively, if you start digging underneath the mountain, right, over here, eventually the mountain starts caving and falling down. This is, of course, a problem. If your house is on top of a coal mine and they remove too much earth from the mine, then your house crumbles into the ground and you have a sinkhole, and now your house is in ruins. Now, so Caitlin, so if you were someone willing to sell your land to a coal mining company and your house is on top, what do you think you would have, put into the contract to selling your subsurface rights? Or what if they did drill on your house? Indemnification, right? So traditionally, if someone sold the land underneath their property for drilling or mining, they would include some sort of indemnification clause. And the indemnification clause would basically say, if in the event you dig under my house and there's subsidence, my house caves into the freaking ground, right? You pay me for it. Right? And indeed, this was the practice in Pennsylvania. Virtually every contract that Pennsylvania coal company signed had these sorts of indemnification clauses in there. And it made sense, right? Why would anyone sell their land, sell the subsurface rights, knowing that their house can cave into the ground? So they said, you know what? We'll give you this property. We'll give you a subsurface right, but you have to reserve an indemnification clause. Okay. So there's nothing wrong when private parties reach indemnification clauses. But in this case, the government stepped in and they enacted something called the Kohler Act. Alex, what is the Kohler Act?
It was a statute that prevented mining companies from mining under a house.
Okay, good. So what the Kohler Act effectively said is that coal companies were prohibited. It was in fact illegal from mining in such a way to cause subsidence. Now, Alex, what happens if the coal company had already reached an agreement that they could mine and indemnify for any sort of damages? What happened to that property right? It was nullified. Everyone see that? By the state passing a law prohibiting mining where there could be subsidence, that nullified any sort of subsurface right contracts the coal companies had, even where they promised to indemnify for the cost of any damages. Okay? Everyone get the basic gist of what happened. So the case arose actually, like, who's Mahon, right? It's funny, the decision doesn't even say who Mahon is. You actually have to go to the Supreme Court of Pennsylvania's decision. Mahon was a property owner. And the subsurface rights of his were actually deeded to the coal company. I think it may have actually been his predecessor, but I'm not entirely sure. And Mahon said, hey, coal company, I want an injunction. I want you to stop drilling because under the provisions of this Kohler Act, you may cause subsidence to my home, right? Not that they did cause subsidence, that it could potentially cause a drop in the house. So Norma, what was the defense then of the coal company to this bill in equity? Yeah. So what's interesting is that this case arose not as a government suing the coal company. There was a private a property owner saying, hey, stop mining. And then the mining company said, wait a minute. This law on which you're suing, this Kohler Act, negates our property rights. We have a property right to dig under here, even if it causes subsidence. And then this new law nullified. It wiped clean that property right. Everyone understand that? So as always, the question in this case begins, and Justice Holmes explains, is this an exercise of the police power, or is this a taking? If it's an exercise of the police power, then too bad to the coal company. Their property rights are gone, even though this basically eliminates everything. Think of Euclid, right? Euclid deprived their property value by what, 80%? Here, it's 100%. They have no use for this land as a coal mine anymore. Or is this exercise of the taking power, in which case the state would have to compensate the coal company for the loss of their subsurface rights? Everyone with me? Okay. So Dominique, how does Justice Holmes go about trying to explain or explore this issue?
There's a talk about how like the right to coal is the right to mine it. So because mining is more for commercial benefit than what public use directly beyond.
Ah, okay. So there's this concept, right, that generally speaking, the police power benefits everyone. So for example, Josh, let me ask you this question. What if the state passes a law, or the city passes a law saying you can't have tall buildings, right? All buildings must be below 10 stories. Does that burden some people? Yeah, so it burdens property owners because they can't build above 10 stories. But who does that benefit, Josh? Who's benefited by that sort of law? Really? You ever been to Washington, D.C.?
Yeah.
Do you like that? Is that appealing to you that there are no tall buildings? You ever been to Paris? Anyone ever been to Paris? Yeah. So, I mean, in theory, at least, if you have a law limiting all buildings to 10 stories, it benefits everyone. You have a more aesthetically pleasing city. You have a more beautiful city, right? Or Josh, I'll give you an easier example, right? Let's say a law says all property must have, 50 feet between each house. Does that impose a burden? Sure it does. What's the burden? You have to acquire more real estate, right? You have to buy more land to have the same size house. But is there a benefit to everyone? It's aesthetically pleasing, right? So there's this general notion in property law, and Justice Holmes describes this in his opinion, called the average reciprocity of advantage, which is a fancy word to describe what I'm talking about. Usually exercise of the police power create a reciprocal advantage, right? Everyone or almost everyone benefits from when there are no nuisances, from when buildings are shorter, from when there's more space, right? There's usually even though there's certain people being burdened, the benefits are spread out over the cost of society. Everyone understand that? We'll get that. The benefits are spread out over the course of society. There's an average reciprocal advantage across society. Okay. But Sam, in this case, in the Kohler's case, who's burdened? coal company is being burdened because their subsurface rights are nullified. Who's getting the advantage?
The surface owner.
Is it society as a whole?
No.
Who's getting the benefit? Just one home, right? And this is one of the points that Justice Holmes makes. Here, the cost is concentrated on one party, and the benefit is concentrated on one party. It's not the case that everyone can benefit from this, because this guy's house falls to the ground, whoop-de-doo, right? It's only one house. Because the benefits are so concentrated on one party, Justice Holmes says that this is not having a sufficient reciprocity of advantage. Okay? Everyone get that much? This comes back up in Justice Brandeis's dissent, which we'll get to in a few moments. So, Mike, in Justice Holmes's mind, at what point does an exercise of the police power become a taking? How do we know when this log, which meant to prevent people's houses from crumbling into the ground, which seems like a good idea, when that becomes a taking? Yeah, okay, so let's build on that for a few minutes, okay? He talks about this diminution in value, right? This diminution in value, right? What is the burden to the property owner? The coal company? And then what is the corresponding benefit to the person above ground? And Justice Holmes, and this is surprising for those of you who read his Lochner dissent to borrow from another class, basically says that this is not really about protecting personal safety. Cameron, how is this not about protecting personal safety? This is about preventing houses from crumbling into the earth.
Well, I mean, the idea is, again, the reciprocity advantage. They're talking about, I guess, in essence, or he's talking about, in essence, focusing, I mean, spreading the benefit across a much larger society. So, yes, the act is there to protect houses from sinking down, but ultimately, they're not talking about that in particular because they're talking about a much larger kind of theory.
You're on the right track. Could the state have promoted safety through least restrictive means?
I think so. I mean,
What did Holmes say about this?
If the regulation goes too far.
No. Kaylor, what did Holmes say about how this could achieve public safety without rendering the property right worthless? What did Justice Holmes say? Oh, know this? Anyone? It's there, trust me, it's there. He says it's not justified as a protection of personal safety. Why? Think about it. Killer, short of prohibiting mining, how else could the government have protected the home above ground? How else would they have done it? How would the property owner above know when to ask them to stop? He can't see what's going on below. How would the property owner above know to tell them to stop? Think about it. Well, no, but that's too late, right? What requirement could the state have imposed the coal company to prevent this? Oh, maybe. What? Notice. Holmes says, why don't you just have a law requiring them to give notice if they're digging underneath the house? Right? Short of nullifying the property right in its entirety, Holmes says, you could do something else. Now, this is very anomalous for Justice Holmes in particular, but even more so for property cases. Usually courts don't give suggestions to the state of how they can enact laws. Usually they say, yes, there may have another, whatever you want, right? Here, Holmes is basically saying this law is not narrowly tailored enough, right? You could accomplish public safety without nullifying property rights. And indeed, Cameron's right. The test that Holmes puts forward, and he says it like this, the general rule, at least, is that while property may be regulated to a certain extent, if regulation, here's the key part, if the regulation goes too far, it will be recognized as a taking. That the police power, if it goes too far, it will be recognized as a taking. Goes too far, huh? Paul, what does that mean?
The regulation goes too far.
Yeah.
I mean, aside from like, they didn't provide you notice at all.
When does a regulation go too far, Paul?
And when it goes too far, if it infringes on your property rights, I mean, if it doesn't even provide you just compensation.
How far is too far, Paul?
It just depends on the facts, but
Yeah, and how are we supposed to know depending on the facts?
just, I don't know, you kind of like know it when you see it.
Yeah. The note when you see a test, then you're in trouble. By the way, that's not actually for pornography, it's for obscenity, and it wasn't actually the majority opinion, which was Stewart's concurring. Josh, what do you think?
I was gonna say, once it's gone too far, then you know. it's
Well,
gone
yeah,
too far.
duh, right? Mike? And how much is that a lot more? Okay, so the test Justice Holmes advanced, unsurprisingly, leaves a lot to be desired, right? It leaves a lot to be desired. How far is too far is very open-ended. He says, in his opinion, this is a question of degree and therefore cannot be disposed of by general propositions. So as easy to apply as Loretto is, right? Bright line rule. Penn Coal was extremely open-ended and would leave a lot of dissatisfaction, which is why Penn Central, in many respects, disregards it, as we'll see in a few moments. Okay? But in any event, this is the test if it goes too far. All right, Marcella, what case would you have thought that Justice Holmes would cite based on the ones you've read so far? Which case do you think would be relevant to this? You've only done a couple, so you have a pretty good chance of guessing. Why do you think that'd be relevant? Or why do you think that Holmes could have cited that case? No, you're not answering the question. What was the test and how to check? Am I blocking? I think I have to stay in front of him. What were the facts and how to check? Why was the state able to ban the baking of bricks or the extraction? How would you characterize digging under someone's land so that their house caves into the earth? How would you characterize that action? Yeah. Yeah, this public-private distinction I don't care about. People from torts, that makes no difference for my class, okay? I always get the exams, I don't care. Why on earth, Marcelo, would this not be deemed a nuisance? Why wouldn't Hadachek provide the rule of decision here? Yeah, why? I mean, this case came 6 years after Hadachek. Why wouldn't Hadachek provide the rule of decision? Yeah, but the person who sold the clay rights did the same. What difference does that make? Jessica, what do you think? Why is Hadachek not providing the rule of decision in this case? What difference does it make? If you're causing a nuisance, you can't contract. You can't. Anyway, what do you think? Why is Hadachek not the rule of decision in this case? Why isn't this case straight up a nuisance? Why couldn't the government merely say that Digging under someone's ground to grow subsidence. By the way, subsidence was a common law nuisance. If you removed earth or the house collapsed, go back to your nuisance chapter. Subsidence was actually discussed there. Anyone? Yeah?
Is it a nuisance after the house collapses or when you're digging?
Well, the digging causes the earth to shift. That itself was a common law nuisance.
Yeah, I'm asking, is it because the nuisance is only there once it shifts, whereas the clay, that stuff was there all the time?
Ben, what do you think?
Is it different now it affected the land property rights?
What do you mean?
So, in habitat, they want prevented from moving or doing whatever they want with the clay. This was made, I guess, inconvenient for them to make it. In this case, they couldn't even mine the coal.
Maybe it went too far. No one else? So, Justice Holmes was an odd justice. I'm not a big fan of his, but it seems almost irresponsible not to at least discuss Haddachek. It had been decided 6 years earlier, and it provides some insight. The court just ignored it, and it was not cited anywhere. I don't know the answer to the question. I always ask. I don't have an answer. Sorry to disappoint, but I'm not sure why the court deemed this not worthy of talking about. All right. So the majority opinion in Penn Coal is if it goes too far, is it taking? Okay. What does that mean? Short game emoticon, right? We don't really know. Like we don't have a good sense of what that means. But what we do know is that there's now this line, and that the court determines, as finder of fact, that something goes too far, it will determine that just compensation must be afforded. And although, by the way, if the state doesn't want to pay for it, that means the law is invalidated. And of course, the state doesn't want to pay. These are valuable subsurface rights. The state's not going to pay for all these coal rights. They can't afford it. So the law is basically nullified. All right, any questions on the majority opinion, Holmes? Okay. The dissent by Justice Louis Brandeis. Justice Brandeis was one of the great progressives who had a very forward-looking vision of the law. And Justice Brandeis's dissent, in many respects, was embraced by Justice Brennan in Penn Central. So it's important for you to actually grasp what Justice Brandeis was talking about. All right. So let's think of it like this. All right. So Haley, let's just pretend, and you may not be able to see this. Let me zoom in a little bit. There we go. You have, Haley. Sorry, yeah, good. So you have a huge plot of land, right? And let's say that they're digging under this part. And let's say pretend this mountain's a house. Let's say your house caves on just this part. What about the rest of the property? What about your rest of your surface rights? Is there any problem there? They're only digging on one part. There's only caving on one part, and the rest of the property is fine. If you're the coal company, you can't dig where subsidence will be caused, right? But usually there's only a house on a small part of land. Can you dig elsewhere where there's no house? So is it true that their entire property rights have been nullified? Okay, why not?
Because they can dig everywhere they want.
Okay, and this is Justice Brandeis's dissent. He says you have to look big picture. Instead of just focusing on the property right underneath the house, right? It's true that the property right underneath the house where subsidence may be caused is nullified. But if we view the parcel as a whole, right? This is the key phrase. The parcel as a whole, the coal company retains significant value. Okay. This idea of the parcel as a whole is what guides Penn Central, our next case. We're not just looking at the air rights above the train station. We're looking at the entire train station, including everything above and below it. So by Brandeis opening this up, not just for the narrow sliver of land underneath the house, but the entire value, he says, listen, it's not going that far at all. In fact, they keep everything else. The only chunk they lose is that underneath the house. We need a bigger denominator. Everyone remember fractions from elementary school, right? Right, you have the numerator and you have the denominator. If we have a big denominator, everything underneath the entire plot of land, the stuff being taken away doesn't actually matter that much. So Brandeis effectively inverts Holmes's approach. Instead of saying this goes too far, he's like, that barely touches just a little sliver of land. Josh? Hmm? What? Ah, good question. But in Loretto, what kind of taking was there?
It was the percent one.
Physical. The government came in and they took something, they banged a nail into a wall. Has the government actually taken the land underneath the property?
They haven't taken it. It's still the bundle of six.
But,
Possession.
okay, but you apply different tests, and you just did exactly what I said not to do, but I'm glad you did it, right? Depending on the nature of the taking, we apply different tests. If the government actually came in and seized the coal, like the raisins, right? They actually took the coal from the ground. That's a per se physical taking, no balancing. But here the government didn't take the coal. They just put a regulation touching the land. And when you have some sort of regulation touching the land, so far we applied this Penn Coal test. Understand? You have to apply the right test. If it's not a physical taking, don't apply Loretto. Don't. Half the class will do that, no matter how many times I repeat this over and over again. You have to apply the right test.
Physical with the hammer.
Permanent physical occupation is a categorical taking, yes.
Okay. And then with control, it's going to be just touching.
Some sort of regulation, right? It's basically a regulation on land use, right? You can say it 100 different ways, but it's some sort of regulation on land use. Okay. Yes, sir.
I mean, for the coal company, if your coal is underground, I mean, that's your value, that's your property, you have to get it out. If the regulation prevents you from getting it out, I don't see how that.
So does a regulation prevent all coal mining? Where does this law actually prevent coal mining?
Well, if it's underneath a habitable structure.
So can you mine everywhere else?
So yeah, you can, but.
So this
I guess
is,
it depends on how much of the land the homeowner.
so this is, yeah, so Jeffrey, this is the difference between Holmes' majority and Brandeis' dissent. Holmes is like, they've just destroyed everything underneath the structure, maybe in a radius around it. But the dissent's like, don't be so narrow-minded. Let's look at the entire value of the land where they get to mine everywhere else. Neither is necessarily right or wrong. Like the Constitution is silent on which is the preferable approach. But Holmes says one of the tenets of our constitutional liberties is protection of property rights. And because as opposed to a burden, we'll take a very narrow slice. Brandeis is saying, no. We should be deferential. We should allow the state to protect people's houses, right? Let's take as broad of a denominator as possible and make it harder to find a taking. Right? Brandeis says every restriction on the use of property deprives the owner of some right. Let this be under the police power. Okay. Everyone get the difference between Holmes and Brandeis here? Holmes says, let's look at just underneath. Brandeis says, let's look at the parcel as a whole. Holmes says, you know, this benefit, this average reciprocity benefit is very narrow. It only benefits one person. Brandeis says, listen, this is benefiting all people who live on top of the land. Okay. Any questions on Penn Coal? Anything? So the Penn Coal test had a good run, but Penn Central, again, don't get confused, Penn Coal, then Penn Central. But Penn Central, in many respects, rejiggered the takings regime in many important respects. Okay, any questions before I get started on Penn Central? Has anyone ever been to Grand Central Station? I'll be going there tomorrow, yeah. I'll be there soon. So in New York City, there are two main train stations. There's Penn Station, which is underneath Madison Square Garden, where the Knicks and the Rangers play, and there's Grand Central Station. Penn Station used to be a beautiful train station. They basically demolished it, and they built, the arena on top of it. So you have this underground, very dank train station. Grand Central Station is quite beautiful. It's very ornate style. It's these beautiful ceilings with all the constellations and gold foil. It's very nice. But as you can tell, here's a picture of the inside constellations, which I took. Okay. All right. But as you can tell from this picture, something weird happened with the skyline. So several years before this case arose, a huge structure was built. It was then called the Pan Am Building for Pan American Airlines. Now it's the MetLife Building. But as a result of building this, if you're looking downtown, you used to be able to see all the way to where the Empire State Building is, where the Chrysler Tower is. But this structure effectively killed that view. And you can see it in this picture. It's literally like right behind the building. It looks almost part of it. And if you're actually, I took this picture on risk of life of a limb because I was basically standing in the middle of the street to take the picture. You're welcome. But if you're looking straight down, you can see the train station right there, and then there's this huge structure right behind it. Basically kills the view. So the background of this case is that New York City said, you know what? We have all these super tall buildings going up. We need to do something about it. We need to have a way to preserve how things used to look. Okay. So Ravashi, tell me about this New York City landmark preservation law.
This law was passed to preserve certain landmarks around the city to ensure that there was no further development and to basically preserve the historic characteristics.
Okay, good. How did it go about preserving historical locations in the city?
It placed restrictions on development.
Good. Okay, good. So the first thing to understand is we've done historical sites before, right? And usually what happens is the city says, you know what, this is a historical neighborhood, and any building in this area that is here, the government needs to sign off before any changes are made to the exterior. You recall we did the case of Bernie v. City of Flores. Remember the church in Bernie, Texas, that they wanted to expand because they didn't have enough people. And the church said, no, you can't do this because it'll change your exterior. In this case, about religious freedom. But the general sense is historical societies do protect sorts of things. But New York didn't preserve historical neighborhoods. Instead, they preserved historical sites. And they selected, I think, about 400 locations in Manhattan that could be used to that had to be maintained in their current appearance. Okay, so after something has been designated a historical site, Aaron, what were the methods that a property owner could avail himself of to try to change how their property looked? Right. So what are the different methods that they could actually do this by? No. There are three approaches that can be used to alter how something appears. Yeah. No. No. Dagny, you have it? Okay, so tell me, what is a certificate of no effect? Okay, so the first method is basically saying we want to make some sort of change, but this will have no effect on how it appears. Okay? Dagny, what's the second method? Okay, so what does that mean? Right, so effectively you have to persuade some board of, city, whatever, that you're going to make changes, but they'll be consistent with the architecture and the use of the landmark. So invariably, buildings crumble, things change, you have to make fixes to them, right? So for example, if the building has one sign and then you just make another sign, you have to have the ownership. So for example, the GE building, right? General Electric building was recently acquired by Comcast. NBC is now owned by Comcast. So they had to change a big General Electric sign to a Comcast sign, right? And this went through years of planning to change the sign in a building. Welcome to New York. So these are sorts of things as you know what, consistent with the building, we have to just change GE to Comcast, whatever. And the final approach is you can say you're getting insufficient return based saying I'm not getting enough money from this property. That is not going to go very far. So effectively, once your building has been so designated as historical site, you are then at the absolute mercy, of the planning commission to try and persuade them that the change you're making is appropriate. Okay, so Yolanda, what kind of change did the train station want to make? And by the way, what's confusing here is the case is called Penn Central, but it's a Grand Central Station. It's not Penn Station, it's Grand Central Station, which makes a difference. So Yolanda, what kind of changes did Grand Central Station want to make to their appearance? Yeah, tell me about this. Okay, good. Why do you think they wanted to add a tower to their design? More money, okay? In a city as dense as New York, you cannot build out, you build up. Indeed, in New York City, they just opened up a condominium tower that's almost 100 stories tall of just condos, not even commercial. The extravagance is quite astounding. So unsurprisingly, they wanted to build a tower on top. And they submitted two of these plans, what's called Brewer 1 and Brewer 2. The first one would have basically maintained the exterior of the train station, but literally built the tower on top of it. So it looks kind of like this train station with a tower on top of it. The second approach would have also built a tower, but they would basically demolish the front of the train station and built these sort of angled barriers to prop up the building. Okay, so Yolanda, what did the planning commission say to these two approaches? No, they didn't. Why do you think the planning commission did not approve of these two approaches? Yeah, right. So effectively, they denied any permit to build either of these structures, saying that it would drastically change the dynamics. It would not be appropriate. It would destroy the view. They should perpetuate these features, not tear them down. And that was that. So Eduardo, after the city denied after the planning commission denied the permits to build, did Penn Central go to court to try to challenge this determination?
Yeah, they
No. Did they seek judicial review of the denial of the certificate?
no, they did.
Okay. So the law provided a means where they could have gone to court and challenged not whether it was a taking, but whether under the law they should have gotten their permit to build. Now, Eduardo, why do you think they didn't bother going to court for that?
Well,
that the site enjoyed a tax exemption.
Mhm.
So that's why it remained suitable for its present and future use.
Oh, no. But even more pressingly, why didn't they didn't bother challenging under New York law if the denial was appropriate? Yeah, they knew they were going to lose. The way the New York law is drafted is that basically the Plan Commission has almost unlimited authority to determine if something's appropriate or not. And as we know, courts do not second guess what a Plan Commission decides is appropriate. That is the province of the courts. Instead, they went and they challenged the law itself. They said the law itself violates the Takings Clause of the Constitution, the Fifth Amendment. All right? So, Chris, under Penn Central, right? Under Penn Coal, Justice Holmes' decision in Penn Coal, how do you think this case would turn out? Forgetting Brennan for a minute, just go back to Holmes. Under the decision in Penn Coal v. Mahon, how do you think this case would turn out?
Well, he would have found probably it was just a private. I think he would have thought it was a private room. I don't think it was been affected society at all.
What was the nature of the taking at Penn Coal? What was actually being done?
They're taking the coal from
No. Were they actually seizing? Were they actually yanking the coal from the ground? What were they doing? That they could not do any business underground, right? The coal was only being used for mining. What were they doing to the parcel here?
saying that they couldn't
Build up. So remember I said that generally speaking under the common law, when you owned a piece of property, you had everything down to this earth and all the way up to the sky, right? So in one respect, Penn Coal and Penn Central are mirror images of each other. In Penn Coal, they were taking the subsurface rights. In Penn Central, they were taking the sky, the air rights above the property. In Penn Coal, they said, you can't dig underneath, even though we can do everything above. In Penn Central, they said, you can't build up, even though we can do everything below. These cases are in many respects, mirror images of each other. Right? But Ryan, did Penn Coal seem to play any role in resolving this case?
Not really.
Well, yeah. Why not?
I mean, the main distinction I would make is that you were talking about like safety or actual damage as opposed to.
Well, in Penn Coal, there was a claim that if they allowed this digging, the house would crumble. Was there any suggestion anywhere that this building would topple over or would cause a nuisance, would be dangerous to the community?
No, other than the fact that it would look different, I guess. I mean, it wasn't really a nuisance claim. It was just a commission saying that they were trying to preserve all these stuff.
Right. So we had these two tests, right? Loretto hadn't been decided yet. Loretto came a couple years later. But we have had a check, which says if it's a nuisance, it's an exercise of the police power. Ryan, is this a nuisance? Okay, then if it's not a nuisance, what test would they supposed to apply?
It's not nuisance. It should be. That would be a thing.
Penn Coal, right. So this is, again, why this topic confuses students every year. The court didn't follow Penn Coal. They fractured off, and they made this new elaborate a framework of how to resolve regulatory takings cases. And let's try and walk through this one step at a time, right? So, Tyler, Justice Brennan, and by the way, if you study Justice Brennan in common law, he was very good at structuring opinions that didn't really say anything. And until the very last sentence, you don't know what you're actually reading. And then the very last sentence will tell you, okay, here's the test you're supposed to apply without explaining it all. He's very good at that. He was a master. So, right. So Tyler, the court, Justice Brennan identifies a few factors to consider in these sorts of land use decisions that affect a person's property. What are these factors?
economic impact, regulation,
Okay.
the extent to which regulation is required, the extent of investment expectation.
Okay, let's go one at a time, okay? You're exactly right. So we have these Penn Central factors. And, you know, this is not a test, right? This is not some sort of bright line rule that can be applied. Rather, these are seemingly arbitrary factors that Justice Brennan pulled out of somewhere. And when juggled up together, they try to ascertain different aspects of what the government's doing. So the first one, okay, is what's called distinct investment-backed expectations, right? So you ask about the economic impact with distinctive investment-backed expectations. DIBs, if you want to be cool, okay? Distinctive investment-backed expectations. Tyler, what the heck is a distinctive investment-backed expectation? What the heck does that mean? What do you think an investment-backed expectation means?
Something that you put money into that you expect is going to.
Okay, good.
give you a return.
All right, so Eric, let me ask you this question. When they filed this lawsuit seeking a permit to build, had they invested any money in building this tower?
To the extent they paid the person, they had the different designs, so they paid for that, that's for sure. But
Had they broken ground in anything?
no, they haven't. I mean, I don't know how that's any more substantial than just getting the plans.
So this is the mystery of the distinct investment-backed expectations. What Justice Brennan says is that in order to show that you've been economically harmed, you need to show that there's some specific money that you've invested to build this sort of thing. But here's the catch-22. Until you get the building permit, you can't invest money. In other words, in order to have these investment-backed expectations, you need to have an expectation that you can build. But until the city gives you that permit, you can't invest the money. This is Justice Brennan at his finest. Making a test that sounds reasonable, that's impossible to satisfy. So unless you had money invested before the regulation came into effect, that is, you were already building this tower, and then suddenly they passed a law and they changed the ordinance midstream, right? You can't prove you have DIBs. Again, this is a test that's basically impossible to satisfy unless you've already started investing money in something. Under modern zoning law, you can't even get a loan to build unless you have your zoning permits lined up. But under this framework, because they didn't have any money lined up, they haven't invested enough money for it to be distinct. Therefore, even though they told the Penn Central company you can't build, it had no economic impact because they haven't even started building, right? The unrealized money from renting out all those floors is, in the air, for literally speaking, in the air for Justice Brennan, because there's no reason why they would have had to expect them. Until you start spending money, you can't expect any income from it. Everyone get that? What you'll see about Penn Central, and if you do research on this, you'll find the government wins in virtually every case. It's almost impossible to show you have these DIBs when you haven't started building yet. Hiring an architect to build your blueprints, that ain't enough, right? Hiring lawyers to go try and litigate to get your permit, not enough. That to be distinct, whatever that means. Everyone get that first element. I don't want to call it a factor, but this is where most taking claims go to die, the failure to have a DIBI. All right. So Josh, what's the second factor that the Justice Brennan looks at?
Does this have to do with, it says taking may more readily be found when the interference property characterized.
Right before that, there's something else. That's the third.
Oh, relevant considerations? Or
After DIBI, You got it?
I think it's the extent of the appearance.
Character of government action. Okay.
So the character of the regulation.
Yeah. The character of the government action. See that? Okay. What do you think that means, Josh? Character of government action.
Well, in the next sentence it says whether it's physical invasion versus just adjusting the benefits and burdens.
Okay. This is where Brennan effectively tries to lay the groundwork for what became Loretto. Okay, Loretto hadn't happened yet, but he effectively says, right? There's a difference. There's a difference between a physical invasion, which we know now is Loretto, that hadn't been decided yet, right? And an adjustment of the benefits and burdens of economic life, right? If there's an actual physical invasion, they're actually taking your raisins or drilling a hole in your wall, that is an easy that's an easy government action to ascertain. But right, but Jack, what happens if all that's happening is that they're merely changing which property values are increased and which are decreased? Is that of a great weight to the court? Yeah. So effectively, what Justice Brennan says is, if it's a physical invasion, that's probably a taking. But if they're merely adjusting who's benefited and who's burdened, that won't cut it. So between these two, and it's actually 2 or 3 depending how you count. Brennan's always very fluid. But between these 2 or 3 factors, depending how you count them, you basically made it almost impossible for a property owner to recover from a taking. Okay. So any questions on that? We'll keep going. We have a lot more. Don't worry. It's a very confusing case. So, Brandon, how do we measure the burden on Penn Central? How do we assess their burden?
You look at the diminished value in their property.
Diminished value of what? Be very precise.
Their property rights,
Yeah, give me more precise.
their ability to.
What was actually taken away from them in this case?
The right to build the hospital.
The right to build the tower. Was that all of their property rights?
Just part of it.
Okay. So Brent, let me ask this question. Under Justice Holmes's approach in Penn Coal, what was the only aspect of the property we were looking at? What was the only piece of land that we cared about in Justice Holmes's analysis?
Actual house.
The land under the house, right?
Line of the house.
Okay. What did Justice Brandeis say we should look at instead?
The whole property.
The parcel as a whole. I remember that, right? From like 15 minutes ago. So here, how do you think Justice Holmes would approach this case?
We say that the regulation goes too far because they're affecting their ability to build their property. the way they
On which segment of the property? What's actually being taken away under Justice Holmes' approach?
want.
What do we call that? Above the building. What do we?
Air right?
Air rights. Everyone see that? Under Justice Holmes' analysis in Penn Coal, we're focusing on the air rights. The air rights have been reduced to a nullity. They can't build anything there. Zero, zilch, nada. Right? But Will, how does Justice Brennan view this analysis? Is he only focusing on the air rights?
Focus on
What-
other people's rights to.
Well, not just other people's rights. What other aspect of the Penn Central property is he focusing on?
Historic value.
No. Is the property value at the Grand Central Station reduced to 0?
No.
Why?
Because it still has its current value, can still operate.
Yes, the train station still exists. The office space, the train station, the shops, and the train station, those still exist. So Justice Brennan, very subtly, adopts Justice Brandeis's dissent. He didn't say he was doing it, but he did it, right? He said, we're going to look at the parcel as a whole. Even though the air rights are reduced down to 0, they still have the train station below them. This is like, don't piss on me, tell me it's raining. Of course they had the train station below. They always had that, right? That was the entire point. They wanted something new, which it now could not. But the Brennan analysis shifts the inquiry. So instead of looking only at the parcel that's being affected, you look at the parcel as a whole. And that was one of the most important moves in the entire decision. Right? He says, we don't divide parcels into discrete segments. We focus on the parcel as a whole. And he says it straight up. Right? And indeed, the law designated the entire block as a landmark site. So Brennan says it makes no sense just to focus on one part of it. We got to focus on the entire law. All right, so questions on that? Again, this is not really a test. To call something the Penn Central test is something of a misnomer, but there are Penn Central factors to consider. Okay, so in Loretto, Jeffrey, in Loretto, it makes no difference of the actual scope of the injury. Putting a little wire this thick on the side of the building, a few dollars, whatever, right? For this analysis, does it matter at the extent to which it impacts the cost, the bottom line? Does that matter here?
Here, no, it wouldn't. There could have been considerable money made,
But
they're relevant in regards to preserving the historic value. And
are they able to make a profit here? Is it Penn Central Company is still able to make a profit here?
I'm sure they're still profitable. I mean, it's desirable.
Yeah. So Brennan says there's a reasonable return on their investment. Imagine that. The court saying, I deem their profits to be reasonable, so there's no taking. People snickering, but this effect what the court said. I deem this reasonable. Okay. So Nali, what were the business? Do you understand these transfer development credits that they can build somewhere else? Did you understand how that worked?
Yeah.
So, want to explain it, please? It's okay.
Sorry, Professor.
That's okay.
Say the question again.
How did these transfer development credits work? What happens if they couldn't? What happens if Penn Central owned 2 pieces of property and they couldn't build a tower here? Were they allowed to build it somewhere else?
Yeah.
How'd that work?
You can build it around.
Yeah. Okay. Good. Good. So what effectively happened in New York was like this. They said, if you can't build something in a site designated historical, you can transfer those credits somewhere else, right? Believe it or not, in New York City, you can't build a skyscraper wherever you want. You need permission from the city. So if you're a big, real estate magnate, like a Donald Trump, whatever, right? And you own, a property that's historically blocked, you can then transfer those credits somewhere else and build a high-rise somewhere else. So Brennan basically says, look, you're given these great options. You can't build a high-rise here, so you can build it somewhere else. Right? So I mean, look, you're not all burdened. All right. So as is common, Brennan, I want you to turn to the very last page of the majority opinion. I don't know the page number, but the very last paragraph. Anyone have the page? Just shout it out. What is it? 1173. The very last paragraph, right? He says, and Brennan does this all the time. On this record, we conclude that the application of New York City's landmark law has not affected the taking of property. The restrictions imposed are substantially related to the promotion of the general welfare and not only permit reasonable beneficial use of the landmark site, but also afford appellants opportunities further to enhance not only the terminal site proper, but also other properties. Okay, that's a test. Alejandro, you want to try and explain to me what that means?
Not really, but I'll try.
I wasn't really asking you, but yeah, go for it. What's going on there? What's Brennan basically saying? There's some stuff there that you can work with.
So I guess saying if the benefit's better for the public, they can't build there, but they can go build somewhere else if it's better for the public there.
Yeah, he's basically saying, look, this benefits the public. Build somewhere else. This is effectively a rational basis style test, right? In so many words, and it's a sort of means and fit. So long as the state has a good reason to protect historical sites, and they can maybe build somewhere else and get a good rate of return, well, the courts aren't going to intervene. If you notice, the stuff about divvies is not here in the sort of last paragraph, but in the 30 or 40 years since Penn Central, the divvies has become a very important aspect. So more so than this last sentence, if I give you a question about Penn Central, and you'll know this because there's a regulation that deprives someone of the value of their property, you need to look at these two factors. This is what you need to consider, and please keep these in your notes that when we go forward. Here? Oh, you okay. So questions on the majority. We'll get to the dissent in a moment. Any questions on the majority opinion? It's a very nebulous test, right? And it basically renders Penn Coal not quite a dead letter, but may as well be. Hey, Josh. Brennan's asking, what is the economic impact of this regulation, right? And you only are economically impacted if you've invested money and those investments are now worthless. So imagine a situation where you started building, the law was one thing, and halfway up your tower is halfway built, they change the ordinance, say, okay, now you need to do something else. You can't build that high. Have you invested money in that? Do you have expectations based on your investments? Yes. Okay. In this case, they hadn't even broken ground yet. There were no investment-backed expectations, even though they had litigated and hired architects. That was not sufficient. But this creates, of course, the catch-22. In New York City, in order to start building, you need the permit. And until you get the permit, you can't invest money in it. So effectively, this renders taking law worthless. And I don't say that lightly, but in virtually almost every case under Penn Central, the government wins. It happens almost all the time. So rather than asking whether regulation goes too far, this test basically says it doesn't really matter how far it goes. Right?
Does this test require that both factors fall on the side of?
It's not that kind of a test where factors weigh. This basically means the government wins. It's really hard to find a case where the government loses under Penn Central unless they invested before. They invested notwithstanding the law. That's really the only circumstance, which is fairly rare in modern society. Any other questions to the majority? Yes, sir.
I have a question in regards to the difference between Penn Coal in this case, because it seems like they're both balancing harm to the public versus the harms to the private citizens.
Right. So how was a balance struck though in Penn Coal? Who was favored?
The private citizens.
And how was a balance struck in Penn Central?
In favor of the public.
Yeah. It basically inverted the scale. So if you think of a scale and you put your thumb down on one side, right? So in Penn Coal, they said, listen, the thumb will be down on the scale of the private property owner. In Penn Central, it's reversed. Here, the thumb was down on the scale of the state.
I feel like it's the same test and just determine the facts.
Well, it's not just the facts, it's how you rig the scale. If you remember, Justice Holmes said one of our constitutional principles is the protection of property rights. That sort of language is entirely absent from Justice Brennan's opinion. That doesn't seem to matter much to him. He says they get a reasonable rate of return that's good enough. Right? Holmes was actually concerned about the livelihood of the coal company. Brennan couldn't give a damn. It's irrelevant to him. For him, what's more important is the state's interest in preserving aesthetics or whatever else. Make sense? Any other question of the majority? So let's see. Greg, what did Justice Rehnquist say in his dissent? What was his approach?
Basically the restriction of airspace was over there.
Yep.
And so he wasn't convinced that the transfer of rights for just compensation.
Yeah. So Rehnquist effectively says, look, this isn't a nuisance, right? This is not Hadachek. There's no claim that this tower will cause a nuisance. Second, he says, this basically turns your air rights into zero value because it can't build anything above it. He would effectively apply Penn Coal to say that this was a taking that went too far. He also addresses the value of whether there's compensation, whether these transfer credits or transfer development rights are in fact compensation. And Rehnquist says they're not compensation. These are very speculative. It's unclear if they can actually use it. And we usually say each parcel is unique. Why should you have to build somewhere else? But the holding of Penn Central has basically stood for 30 years and really has not been disturbed. Any question of the Penn Central dissent? Okay, so far you guys have like 3 or 4, depending on how you count, tests, right? If there's a physical taking, an actual physical taking, number 1, it's categorical. It's a per se taking. There's no balancing. If there's a physical taking on the exam, I don't want to hear about divvies. Okay? You tell me Loretto, say it's a categorical taking, done. Second, you have Hadachek. If the government is acting to police a nuisance, that'll be an exercise of the police power. And therefore, there's no compensation necessary. It's not a taking. The third or fourth test, depending on how you count, is Penn Central or Penn Coal. Penn Coal is not really good law anymore. Under Penn Central, if there's a land use regulation, right, that impacts the value of a property, you ask about these 2 factors, right? Whether the property owner had these distinct investment-backed expectations, and you question the character of the governmental action. Really, factor number 2 basically asks, are we Loretto or not? That's what factor number 2 is asking. Because if it's a physical taking, you go to Loretto, and you know how that one ends. So really, the only factor that matters is number 1, has the government, has the property owner had in fact these investment-backed expectations? The answer is almost always no. So we get to this weird place, right, where if it's a Loretto world, if it's a physical taking, well, in that case, it's always a taking, right? If there's actually a physical occupation, it's always going to be a taking. Compensation is always necessary. With Penn Central, we get to the case where if there's no physical taking, basically the government always wins. So depending how you frame it as a permanent physical occupation or some sort of a land use regulation, the outcome is very much determined. Okay. Questions on Penn Central? Okay, again, no class on Wednesday, and on Monday, Justice Busby will be here. Please be on your A game. Thank you very much.